Good evening, everyone, and welcome to another First Friday event sponsored by the Town of Woodside's Arts and Culture Committee, a group of like-minded individuals who want to promote culture and art through presentations to our town. Now, this evening, we have a subject that we've never really broached before. We've had music and art and history and photography, but this evening, we have a very unique presentation for you. And I feel quite honored to have this presenter come forward and do this for our community. Judge Cordell was the first African-American woman to sit on the bench of the Northern California Supreme Court. That alone is an amazing feat. But when you read her book, as I have, and learn her story and learn all of the challenges of being a judge, not just because she's an African-American woman, but just being a judge, that is an amazing story and one we're fortunate to hear a part of this evening. Now, the interesting thing about judges are that judges are like umpires. And umpires don't make the rules, they apply them. The role of an umpire and a judge is critical. They make sure everybody plays by the rules. And nobody ever went to a ball game to see the umpire. Now, that's a quote from John Roberts, the Supreme Court of the United States. So without further ado, I would like to welcome you to step up to your computers and hear the amazing story of Her Honor, Judge Cordell. Thank you.
I'm Corinne from the Woodside Art and Culture Committee, here with Judge LaDoris Hazzard Cordell, who has spoken to CNN, MSNBC, Commonwealth Club, NPR, ... But now she's here for the Woodside Art and Culture First Friday. So thank you, LaDoris, for making the time to educate, entertain, and energize us with discussion and teasers from your recently released book, which discusses some of your groundbreaking and glass ceiling shattering accomplishments and innovations, and some frustrations.
So Corinne, thank you for inviting me to join you at Woodside Arts and Culture First Friday. But for you, I really didn't know about First Friday. And so thank you for, first of all, doing what you do to bring all kinds of information to the folks who attend these events. And I'm just delighted to be able to talk to you, one, as a friend, as a fellow yoga person, and also somebody who just really cares about these issues. So I thank you, and I'm just delighted to talk about Her Honor.
Well, I'm very excited that you're here. So let me show your book here. And there you are, the book, Her Honor, My Life on the Bench, What Works, What's Broken, How to Change It. It was released last October, and it details the good, the not so good, and some of her ideas for fixes. It's divided into chapters, or she calls them war stories, on diverse judicial issues. And let's talk a little bit on that. Let's discuss, and I love this story, what were the source documents for this book?
Right. So let me just go back a little bit more and talk about the writing process, and I'll get to how this book came to be. In June 2019, I began writing this book, Her Honor, and it's about my nearly 2 decades on the bench here in Santa Clara County as a state trial court judge. It's part primer about the world of trial court judges in the states, and it's part memoir about my nearly 20 years on the bench. So I call it kind of a primoire, part primer, part memoir. It's kind of a genre I created. So the one and only silver lining about this pandemic was that it forced me to stay home and to write. What better time to write than in a pandemic, because you can't go anywhere. So I ended up writing the book. I spent 4 to 5 hours every day for 1 year writing this book, but there would have been no book. And this is what you're getting to, I think, but for my parents who, and the reason I say that is that every Friday during the last 7 years that I was on the bench, those are my parents there. You can see them, Louis and Clara Hazzard. I wrote letters to my parents, and I wrote every Friday because Friday afternoons, judges, if you're a trial court judge, that's when you don't usually have cases and you're preparing for the cases that come in on the following Monday. My parents loved hearing about everything going on in the courts. So I started writing about everything. So the cases, the names of the people, the decisions I made. And I also wrote about how I felt when I made these decisions. So these were, Corinne, these were letters. These were not emails and, little soundbite kinds of things. These were real letters that I typed up and then put in an envelope and put a stamp on the envelope and mailed to them. So after I retired, and I didn't make any copies of any of these letters. So after I retired from the bench, I visited my parents back on the East Coast, and my mother, a couple days into the visit, she pulls this big box out of the closet. My mother was a very organized person. And she said, "What do you want me to do with these?" My mother had saved every one of those letters. So I boxed them up. I shipped them back here to me in California. And it took me about 3 years before I started to just look at these letters. And it was really then that I got the idea to write about my experiences on the bench. But without those letters, I would never have recalled the stories that are in the book. So what I like to do is just read a little passage from the first chapter called Bitten by the Judge Bug. And it's what I wrote about my parents. Louis and Clara Hazzard had worked hard to provide for us and to ensure that my 2 sisters and I went to college. Their mothers had been the help, domestic workers who toiled for next to nothing, serving wealthy white families who resided in Philadelphia's prestigious mainline suburbs. When my mother, a high school graduate, and my father, a graduate of North Carolina Agricultural and Technical College, married in 1943, they had neither an inheritance nor a nest egg to get them started. What they did inherit, though, was a terrific work ethic and a powerful drive to succeed. My parents would come to own a home and operate Spring Cleaners, a dry cleaning business that supported our family for 40 years. So thanks to my parents, we have this book.
I love that story because I, on every Sunday when I was living in Southern California, wrote similar letters to my parents.
So yeah,
mine were in longhand.
Yeah, oh, that's even better, but I really think that we've lost in America, we've lost the art of letter writing. And I think it's so important. People love to get letters,
right?
Except from the IRS, but letters are just so nice. And I'm hoping that there is a renaissance, that people once again resort to writing letters to one another.
I think that would be great. Although longhand, I'm not sure. Let's discuss a little bit about your early time in the law. Oops, let me see if I can get to that. There we go.
Sure. So before one can become a judge, one has to practice law, and that's true of every state. In California, you have to have a minimum number of years. Today, it's 10 years before you can be a trial court judge. But back in the early 80s and before that, it was a minimum of 6 years practicing law to be appointed to the municipal court, which is the lowest level, the trial courts. Today, the trial courts, the municipal court and superior courts in California were consolidated in the mid-1990s. But back then, when I wanted to be on the bench, there was this municipal court. So what you see now, this image is showing that after I was appointed by Jerry Brown in 1982 to the bench, and one has to apply for a judgeship, and I write all about that in the first chapter of the book, Bitten by the Judge Bug. So when I was appointed, I became the first African-American female judge in all of Northern California. And so one becomes a judge find you don't just go to work. You have to have an investiture. It's really a ceremony where you put on the robe and you're administered an oath. So you see here my investiture in 1982. I was 32 years of age then. I had 2 daughters, as you can see there. And that's my ex now, my then spouse. And there's my parents, Louis and Clara Hazzard, putting the robe on me. And this investiture was at Stanford Law School. And then one has to be sworn in. And the person who swore me in is the person you see there. His name is Felton Henderson. He is a federal judge who recently retired from the bench. And Felton became a very, very highly respected federal judge in the United States, albeit he was based in Northern California. And Felton swore me in that day, and also just remained to this day a dear friend and a mentor when I was on the bench. So after I was sworn in, I set forth to mete out justice, as I note in the first chapter, untrained, untutored, and unnerved.
Can we look at some of those diverse specifics of your chapters? You've dealt with criminal, with adoption, with family matters, with estates, with that.
Yeah, before you go to the next image, I just wanted to explain to folks so people really understand what you have described is exactly the world of a trial judge. It's diverse subject matter. It's one big drama, which is why the fact that I majored in theater in college was really the best preparation I could have had for, first of all, when I was a lawyer, being a litigator, good preparation, because as a litigator, my audience is a jury. I have to persuade them. And even better preparation for a judgeship, where in the courtroom, I'm the producer director, right? Everybody does what I tell them to do: sit, stand up, talk, not talk. So, and anything goes in the courtroom. People lose their inhibitions. And when that happens, I tell people, just hold on to your hats. And so in her honor, as you know, there are lots of stories from the variety of cases over which I presided. So if we want to talk about one of the types of cases, that's great.
I'm working on that.
All right. So I have a chapter in the book about probate court. And probate court is when somebody dies, people fight over the spoils. And so that chapter is called, as you can see, Where There's a Will. And so I'll give you just one story from that court. I tell the story about a wealthy inventor, a Stanford Business School graduate who left his entire estate to Tom, Dick, Mary, and Kim. They don't have last names. Why don't they have last names? Because they're not people. They are 4 feral cats. And I kid you not. So let me, while that's up there, let me read you from the book what I wrote about this. It's just a short passage. So the Walton Trust provided that $600,000 was to be used to maintain these 4 cats. And I quote from the trust, in a most pleasant manner and pleasing atmosphere, that as I have been accustomed to give them during my lifetime. And what lawyer came up with that wording, I wondered. The trust also bequeathed $3 million in real estate to 7 animal charities. The 3 lawyers who represented the 7 animal charities contended that the trustee had improperly used the trust assets to pad his pockets. Preferring mediation to litigation, I spent several hours in discussions with the attorneys and worked out a settlement. Most important, I ordered that Tom, Dick, Mary, and Kim should continue to live in the comfort and care to which they had grown accustomed.
Well, of course.
So, yeah, as I said, there's a lot of drama in courts. You never know what you're going to get. So probate, of course, has some very serious aspects to it, and I certainly write about those as well.
Right. Well, you mentioned unexpected, and I think on another vein, something unexpected might be the reaction to some of your humorous artwork. because now there's
Ah,
another,
yes.
and this might fit under the category of entertainment.
Ah,
Let's look at the chapter called Bad Judges.
yes, I have a
And-
chapter called Bad Judges where I profile some really bad actors in black robes from around the country. These are trial court judges. And yes, Corinne, yeah, I included myself in that chapter because some cartoons that I had drawn didn't sit well with a few of my colleagues. Now, I had donated the cartoons that I had drawn to Legal Advocates for Children and Youth. It's the nickname for Lacey, a nonprofit. And Lacey used my cartoons and published them in calendars, and then sold the calendars to raise money to provide legal representation for young people. So before you show an image, one of the cartoons, let me just describe it from the book. This is from the book. The drawings depicted judges, lawyers, jurors, and me in humorous situations that illustrated common legal terms. In the first 3 months of 1999, calendar sales generated more than $9,000 for Lacey. In June, I received a letter from the Commission on Judicial Performance informing me that an anonymous complaint had been filed against me, alleging that my cartoons, and I quote, impugned the integrity, impartiality, diligence, sobriety, and competency of the judges depicted, potentially eroding public confidence and respect, end quote. Well, so never mind the long and revered tradition of parody and satire of our legal system by such famous cartoonists as like Charles Bragg and in France, Daumier, and never mind the protections of the First Amendment. So here's what all the fuss was about. And you'll see this cartoon now. All right, so this is why I was labeled a bad judge. This is a cartoon that I drew, and it just depicts a generic white guy judge, and he is holding a bottle of liquor. You can see it's Johnny Walker Red. Behind the judge on the wall is a calendar, and each day on the calendar it says golf. And at the very bottom of the calendar, the bottom dates, there's a line in the middle, and that says retirement. And then after it, it says more golf. Okay. So the idea is these cartoons depict legal terms. You try to guess what the legal terms are. So on this one.
I know.
What is it?
This is take the fifth.
Take the fifth, right? He's holding a fifth of liquor, and a legal term, take the fifth. So it's very concrete, but it's all for fun. So there were, as I said, judges who were not happy with me about that. Well, there's also, I'll just show a few more. There were a total of like 5 cartoons that got me in trouble. So here's another one.
There.
So this looks like Newt Gingrich. That's who I intended it to look like, a parody set. And he's holding something in his hand. You can see it. So Corinne, what's the legal term?
This would be cross-examination.
Exactly. You're so good. So cross-examination. Again, very concrete, just a legal term. No big deal. It's funny. It's supposed to make you laugh. Okay, one more. And this one shows a variety of people. And I even drew myself sitting at the bench there, and everybody's doing weird things with their arms in their hands, moving them around in all different kinds of ways. So you want to take a guess at this one?
I like the right to bear arms, or maybe the long arm of the law, but I was wrong.
Wrong and wrong. Sorry.
I know that in fact it's make a motion.
Make a motion. So everybody, and that's a legal term, and everybody's making a motion, some sort of emotion with their arms or their hands. So, all right. So I get a complaint filed against me. I get brought before the Commission on Judicial Performance and asked to explain myself. And so what happened? I'm not going to tell you. I'm not going to tell folks who haven't read the book. It's a teaser. And let me just say, what you think might have happened, like, not a big deal. Well, think again. So I'll just leave it at that. And in that chapter, so I write about bad judges, I write about my own experience, but I also write about the whole systems across the country that discipline judges that don't behave. So people will learn a lot about how that whole system works. And one thing people will get from it is that there is very little transparency in the disciplining of judges.
Yeah, yes.
Not good, by the way.
There are
Not
some
good at
reasons
all.
the judges should be disciplined, but
Oh, yes.
there are some that
Yes.
they shouldn't be.
Yes.
All right, so let's you mentioned in your book energize. So let's talk about how you feel about jury duty.
Okay, thank you. So preliminarily, there are about 15 different topics in the book. And juries, I think, are really, really important, and they impact all of us. So there's a chapter called Thank You for Your Service. The right to a jury trial is enshrined in 3 places in the US Constitution. Article 3, the 6th Amendment, which says a speedy trial is required in criminal cases, and it's mandatory for all the states. And then there's a 7th Amendment, which says that juries can be held in civil trials where people are suing each other, and it's optional for the states, but every state has indeed opted in to require juries for civil trials as well. So I loved jury trials because I'm a people person, and I saw these trials as ways to introduce people to our legal system in the hope that jurors would have a good experience and feel good about the legal system. So Corinne, have you ever served on a jury or been called for jury duty?
I was tossed off a jury.
Oh, tossed off, meaning
I know
you-
I was not accepted. I was, yes.
you were excused.
Yeah,
Okay, so you didn't
yes.
actually, you were there, you got your jury summons, but you didn't actually serve on a jury.
Right. I was pulled in, they asked me questions and they said, no, we don't like you.
Well, I don't know if it's not like you, but it's very subjective, some of this stuff, right? So
Yes.
jury selection, what you went through, and by the way, I've never served on a jury and I would love to do it. But jury selection, I found fascinating. I found it amusing. And I found it annoying when people who saw jury service akin to the plague did their best to get out of jury duty. So it's my hope that those of you who are watching this program, that if you had served on jury duty, that you had a positive experience. But I can understand why many people avoid jury duty like the plague. First of all, there's the time wasted just sitting around for hours. You're sitting in this big room with other jurors. You don't know what's going on, and it tends not to get explained to you. And then there's the compensation, or I should say the lack thereof of compensation. So this is from a chapter in the book from Thank You for Your Service. Most, let me start with, most judges see the jury trial as an opportunity to lecture prospective jurors about the importance of jury service as a civic responsibility. But when jurors are paid as little as $5, $15, or $50 a day for their service, what does that say about the perceived value they bring to our legal system? So as an example, I note in the book, juror fees range from a high of $50 per day, Arkansas, North and South Dakota, and in the federal courts, to $5 a day, New Jersey and Kentucky, to nothing, Delaware and South Carolina, and everything in between. California is near the bottom, coming in at just $15 per day. And that doesn't count the first day. You don't get paid for the first day of jury service. Right. And when full-time employees are called for jury duty, only 8 states and the District of Columbia require employers to pay their regular wages during jury service. So I have a chapter in the book, it's the next to last chapter, called The Fix, where I have suggestions for things that can be done to make our legal system better. And one of the fixes I propose is that the states establish jury compensation funds to adequately pay jurors. And I recommend that large employers, we're talking like Google, Facebook, the big ones, that they be required to pay their employees who serve on juries, because all these big companies, almost all of them, do not do it. And in California, they're just not required to do it at all.
I had a good company that did.
So that is highly unusual. And there are some that do, but they will only do it for maybe 3 days or 5 days. Well, what if you're on a jury that goes for 2 weeks or a month? So how can you be expected to serve and then you don't get paid? So I think these big companies should be required to pay, and smaller companies that cannot afford to pay full salaries of their employees. We're talking, they have 5 employees. they cannot afford to pay someone who's not there at work, then that's where the jury compensation fund comes in, and they get paid whatever their salary is from this fund so that they can do jury duty, provide a civic service, and at the same time not have to worry about how they are going to make ends meet by not getting money.
Right, right. And the other civic service that it allows us to actually make a difference in what happens in the legal system is to vote, to register early, and then to vote every time you get the opportunity, because that's, from a lot of our perspective, that's about the only way you can possibly have an impact on what's going on in our legal system.
Absolutely. And that brings me to another subject that I address in the book, and that is judicial elections, voting for people who want to be judges or who want to continue to be judges. Right. So if I can just give a little background, as I write in the book, there's a chapter, there it is, Judges for Sale. And so just as a little background, judicial elections were first instituted in the late 1770s and the early 1800s, when the then territory of Vermont and the states of Georgia and Indiana used them to fill seats on their lower courts. Then in 1832, Mississippi became the first state to adopt elections for all of its judges. And the rest of the states' governors appointed judges to lifetime terms during good behavior. So as some of you may know, and I write about this in this chapter, I was able to secure a seat on the Superior Court in Santa Clara County as a result of a county-wide judicial election in 1988. And you're seeing now a brochure. So I had brochures, I had lawn signs and mailers, and I ended up winning that seat. It was a vacant seat. A judge had retired, and I was vying for the seat against a prosecutor who wanted the seat as well. And I defeated him, and I won with 62% of the vote. In my book is a chapter in the Judges for Sale. I described that election experience, and I'll tell you something, I wouldn't wish it on my worst enemy. Why? Well, first of all, it takes money to run for a judgeship. I had to raise money, and I raised $70,000. In today's dollars, that's about $150,000. And that money mostly came from lawyers, some of whom appeared in my court. Well, I think that's a problem right there. I mean, lawyers who have given you money, but then here they are in your court, and it doesn't have a good feel to it, and not a good appearance of impartiality, even though I believed I could be impartial, and I was, but still. And that amount of money I raised is a pittance compared to today's judicial elections. So I'm going to read something from the chapter Judges for Sale about judicial elections, just a short passage. During the 2015-16 Supreme Court election cycle, political action committees, social welfare organizations, and other non-party groups engaged in a record $27.8 million of outside spending, making up an unprecedented 40% of overall Supreme Court election spending. This is for state Supreme Courts. Unsurprisingly, 56% of that money was contributed by lawyers, lobbyists, and corporate interests. And after the 2010 US Supreme Court decision in Citizens United versus FEC allowed an unlimited flood of money into political campaigns, the floodgates to state judges' campaigns opened as well. So, Corinne, there is more. And as the influence of money in judicial races grows, so does its impact on judicial decision-making. And this, again, from the book, is so serious. The Brennan Center for Justice analyzed 15 years of television advertising data for state Supreme Court decisions to gauge the ads' impact on judicial decision-making in criminal cases. Generally, the ads attacked judges for being soft on crime or praised them as tough on crime. 3 of the center's findings were: 1, the more frequently ads aired during an election, the less likely state Supreme Court justices were to rule in favor of criminal defendants. 2, closer to their re-elections, trial judges in Pennsylvania and Washington sentenced defendants convicted of serious felonies to longer sentences than normally imposed for those crimes. And 3, trial judges in Alabama imposed death sentences more often in election years, sometimes overriding life sentence verdicts handed down by juries. So judges are not politicians.
Right.
Politicians make promises to voters to appeal to whatever it is their constituents want. But unlike politicians, judges are independent. The only promise that judges can ever make is to adhere to the rule of law.
Right.
Judges are held accountable in other kinds of ways, but it is really, really critical that judges not be treated as politicians. So it's my view that judicial elections, I think there's an image of me where, yes, so showing that I won the election. And I'm, as you can see, I'm high-fiving the presiding judge, Peter Stone, after I was sworn in. So this is my second investiture, right? The first one I was appointed by the governor, this one where I won a seat. And there's my mother. You can see my younger daughter standing to the right of me. My mother's on the left of me. Well, it's my view that judicial elections should be replaced with independent nominating commissions that are bipartisan, appointed by diverse stakeholders, that they include non-lawyers, and that they have clear criteria for vetting candidates for judicial offices. The nominating process should be open, should be transparent, and with publicly available data about the diversity of the applicants and nominees. So we get back now to the issue you raised, Corinne, which is about voting. And so until we rid ourselves of judicial elections, I really want to get rid of them. We need to do a better job of educating voters.
Right.
And I can't tell you how many times I've gotten late night phone calls from neighbors asking me who they should vote for in judicial races. They know nothing about them. So we
Exactly.
need meaningful voter guides that include detailed profiles of the judicial candidates, including any results of evaluations by lawyers that are occasionally done by the courts.
Right.
Voting right now is absolutely the key, but it's got to be an informed voter that's deciding who should fill these judicial positions.
Right, right. And yet finding all those people to do the proper nominations is going to be a challenge as well.
Yeah, but I mean, it's like, I could see, for example, Corinne, I could see you sitting on a commission along with other people, looking at people coming forward. And I talk in the book about how I think judges people who want to be judges, first timers, that they should audition. They should be observed presiding over maybe small claims cases, and that's where lawyers are not permitted. It's like what Judge Judy hears now, but not do it in the way Judge Judy does it, but that preside over cases. And I think that it should be a wide array of people to choose those. And what happens is they choose a number of candidates and they go to the governor, as I write in the book, and the governor then chooses from those candidates that have been fully vetted transparently by this nominating commission.
But not all governors are easy to deal with.
This is true. I can think of one.
Yes, well, as you pointed out, your investiture was 1989, but you were elected in 1988.
Ah,
so
point.
Perhaps
So
a teaser about.
Yeah, there's 6 months there. I got this empty seat in June. It's empty, but I couldn't get sworn in to take it until 6 months later. And thank you. That's another teaser. Why was that? And it had to do with a governor clashing with me over a seat I had won. Yes.
Yes. All right, let's move on to another serious topic of, again, why judges should not be elected and are not regular politicians. They really aren't politicians. Yeah. Let me share this screen. There you go.
Yeah, there's a chapter in the book called Jacques Judges Under Attack. So what I like to do is just read the first 3 sentences of that chapter. There is frequently no warning or signal that a judge's decision is destined to blow up in her face. It could be her umpteenth sentencing decision in her umpteenth criminal case, but for whatever reason, one decision takes on a life of its own with disastrous consequences. That's what happened to Santa Clara County Superior Court Judge Aaron Persky.
Yeah.
So in 20, if you'll leave that up there for a little bit, in 2016, Judge Persky presided over the criminal trial of a 19-year-old Stanford freshman who was charged with sexual assault of a 22-year-old woman, a college graduate. Both were at a fraternity party and both were highly intoxicated. A jury convicted the student who, before he was even charged with a crime, had been expelled from Stanford. And after Judge Persky sentenced the student to 6 months in jail, the recommended sentence by the probation department, all hell broke loose. He became the target of a recall campaign coordinated by a female Stanford law professor who has never passed a bar exam, has never represented a client, and who has absolutely no experience in criminal law, and who was outraged that the judge had not sentenced this student to state prison. So what the recall deliberately ignored was that the punishment handed down by Judge Persky, not only was it lawful, but it included ordering this student, this 19-year-old, to register as a sex offender for the rest of his life. So before the recall campaign was over, the name Persky would become infamous throughout the country and beyond. So there's a next image, just to give you an idea of how misconstrued things became. You'll see here, this was a mailer sent out by the recall campaign, and it says Judge Aaron Persky sentenced Robert Chain to only 4 days in jail for felony child pornography. Now, if you're just seeing that and you read it, you're outraged, like, wow, child pornography, a felony, and he just goes to jail for 4 days. What's wrong with that judge? That's what you'd think. Well, what's not contained in this is the truth. The truth is that it was the prosecutor, the DA, who entered into a plea bargain with Mr. Chain and his lawyer. And it was the DA who asked the judge to give Mr. Chain 4 days in jail. In other words, this was a plea bargain. But that's not what you get from just looking at that piece. So if you show the next image, you'll see that I became, this one, I'm sorry, this is another image where, again, they are trying to show Judge Persky somehow is tainted by putting the picture of Donald Trump next to him. I mean, what happened in this recall campaign, in my view, was just outrageous. So on the next one, you'll see I became a spokesperson on Judge Persky's behalf in opposing against the recall, because the campaign, as I've just demonstrated to you, lied about the judge's, what he did, lied about his track record. I became a spokesperson because the sentence he imposed was within his discretion. It was entirely lawful, albeit controversial. It was lawful. Because also the judge was not legally allowed to speak about the case. The judicial rules did not allow that. And most importantly, I became a spokesperson because the recall posed a threat to judicial independence. Aaron Persky was recalled, supported by an infusion, you can show that one now, of millions of dollars. And as you can see, more than $3 million spent to recall a judge who'd been on the bench for 12 years, an impeccable reputation, who'd made one decision that was lawful, but that some people disagreed with. So we're back to judicial independence. These two words have never been more misunderstood, more distorted, and anathema to so many people. Yet judicial independence is critical to maintaining our democracy. And as you can see, as far back as the 1700s, judicial independence was recognized in the Declaration of Independence when the Continental Congress penned its 27 grievances against King George III, writing, "He has made judges dependent on his will alone for the tenure of their offices and amount and payment of their salaries." So the question becomes, and I want people to understand, I didn't write this book just to complain. I wrote this book to also suggest fixes. So again, in the chapter called The Fix, I suggest what we can do to ensure that our state court judges maintain their independence. Now, recalls, for example, they have nothing to do with the federal bench. Federal judges can never be recalled. They're there for life. But state court judges are subject to recall. So in California, well, first of all, just go back to the other one for a moment. So the question becomes, can we go back to the other? There we go.
Sorry.
So the issue is, this is a serious issue, because when we lose our independent judiciary, we lose our already fragile democracy. So in California, the Constitution, Article 2, the California Constitution, is just one sentence that says recall is the power of electors to remove elective officers. The problem with this is that this paints judges with the same brush as politicians. And judges, as I've said earlier, are not politicians. So I do propose in the chapter, in the fix, that we have, I think we need to go back one more,
Okay.
There we go.
Sorry.
So what I propose is that we don't abolish judicial recalls, but we limit them the way it is done in Georgia and Minnesota and Montana. And more specifically, no, go back to where we just had it. Right there, Georgia and Montana. So recalls in these two states can never be based on a judge's lawful decision, no matter how controversial. And I believe that's how it should be done in California. So if you go to the next image, you'll see that's what it says in California. And the fix that I propose right there is that it be modeled on what's done in Georgia and Montana. So in other words, we keep the language, recall is the power of electors to remove elective officers. But we add the language I have there highlighted in yellow. I mean, I just came up with this language, but I think this is what should be done to preserve our judicial independence. So with the exception of judicial officers who may be recalled only upon one or more of the following conditions: the judicial officer has engaged in misconduct, failure to perform duties of the office, or conviction of a serious crime while in office. No judicial officer may be recalled for a discretionary performance of a lawful act or mandatory duty. And I also believe that if our legislators will not take the lead in amending our Constitution, by the way, it's been amended more than 200 times, then we, the people, the voters in California, should use our influence to make this happen. Use our influence on legislators, and also, if they still won't listen or don't have the courage, to even use the initiative process to change the Constitution to preserve our independent judiciary in California.
I agree, for what that's worth.
Well, it's important, and I hope that others agree. This is just, I can't stress enough. I made decisions when I was on the bench, and I write about in the book that were controversial, where I sentenced a juvenile to 1 year in jail, and after I'd found her that she was guilty of felony murder. And I caught hell, and there were headlines, judge gives, murderer a year. Well, there was a lot more to it. I wrote a long decision, and there's no way that I would be the subject of being recalled. Today, in today's world, I might have been, had I done this today. So I just think it's really, really important.
And I think that's a good point that you put out, that there were some frustrations in your work with campaigns being waged against you by as you'd see in the book, a diversity of people, birth fathers, the people involved with Jessica, that was only put into a camp for 1 year. And then there's that governor and your co-judges over the cartoons. So you retired in 2001. You moved off the bench. You moved back into working with Stanford as special counselor to the president. You'd been frustrated with not only these campaigns, but with the fact that when you made a judgment, it sometimes couldn't properly be implemented, and that there were rules that had no give to them, that you had no choice to modify.
Yeah, and these are important points, and I'm glad you picked up on them as you read the book, because the two things I just want to make, points I want to make is that this term activist judge, it's been used really in a negative way, because an activist judge is usually viewed as an outlier, somebody who's gone rogue, and that's not good for our judiciary. At the same time, I describe myself in the book as an activist judge, and by that I meant I believe that judges, every judge should be an activist in the sense that you're doing everything you can every day you have that job to make the legal system better. And so the activism for me was to implement new programs, to try to make a difference, to make it so that justice could be done and done properly. So in that sense, I was an activist judge. And what I learned from all of that is that systems resist change, and the legal system is no exception to it. And when I try to make the system do better by implementing new programs, I got this pushback. And I write about that in the book. And as a way to say, it isn't always easy, but as I also write in the book, I persisted. And in some cases, I didn't prevail. In some instances, I did. But all of that, again, is all written in the book about the kinds of things that I believe trial judges should be doing. And the other is that, I retired from the bench, as you noted, because there were laws that I had to enforce. So if you're a judge, you can't pick and choose the laws that you want to uphold. You have to uphold all of them, even the ones that you don't like. And for me, I did not like these mandatory minimum sentencing laws, which are 3 strikes laws, for example, that paint all defendants with the same brush. Now, as a trial judge, you're supposed to look at the background of each defendant, to look at the circumstances, what brought that person to commit this act, as well as to the circumstances of the victim. You're supposed to look at all of this, but mandatory minimum laws don't permit that. Everyone just looks the same. We don't care about terrible things that happened to that person who went on and did a terrible thing. Well, we should, but the laws didn't. So I ended up retiring from the bench because I just felt I could not continue to enforce these mandatory minimum laws. But what I did, and I write about this in the last chapter, is I wanted to somehow bring change in dealing with these mandatory minimum laws. So I write about what I did once I left the bench by undertaking a case to help someone who had been subject to these mandatory minimum sentencing laws. So I hope people will read the book, yet another teaser, to see what happened in that case and how that person's life was impacted.
So you have such a diverse set of experiences on the bench, and you are so in support of diversity that dealing with, there are no changes that can be made to this law, had to be really difficult for you. Your life has been diverse. You've been so innovative. You've been breaking through, you've been groundbreaking and breaking through glass ceilings both, and breaking stereotypes. I think we have one more slide here that I think shows and let me see if I can get to it quickly.
Sure. There we go.
So diversity.
So you talk about busting stereotypes. So this image shows the various hairstyles that I wore during my time on the bench. So if you look at the bottom middle, that's 1982 when I started, when I was sworn in and appointed by Jerry Brown. Then you look over to the left there. That's me when I won election to the Superior Court in 1988. And you can see little bits of gray in my hair there. And then as you go up around and above, you'll see I had short dreadlocks, then I had short hair, then I had a box. And then you look, the lower right-hand corner is very short. And so, the question comes, why are we even showing this to people? Well, one, it's my story. And my story, I can tell you pretty much where I was presiding over what I was presiding by my hairstyle. So I wore my hair like this, one, because I could, because if you have hair like this, have, Black women's hair, I can wear my hair in these different kinds of ways. But I also wore my hair like this, as you noted, Corinne, to bust stereotypes, to say to people, judges can look like this. Deal with it. And let me tell you, when I would come out on the bench wearing a box or wearing a short dreads, the looks I'd get from some people who were the spectators or litigants waiting here, they would either be frowns or kind of, what is that? Or some smiles. But the whole idea was, I knew I might get these responses. It didn't matter because it's a statement. Here I am, and deal with it. And it's really interesting to note that in 2020, the Crown Act was enacted in California, the first state to ever do this, to ensure that no one can be discriminated against in the workplace on the basis of how they wear their hair. And that law came about in response to rampant workplace discrimination against Black women who chose to wear natural hairstyles. So now anybody, whatever your ethnicity, whatever your type of hair, you cannot be subject to discrimination in the workplace because of hair. So little did I know that hair would be so important,
Leading edge.
Further on. Exactly.
So I know one of your favorite quotes is, and you'll be able to reference it better than I, activism is my rent for living on the planet. And you are living that life. Your activism, your innovation, your development of a judge school, because when a judge is first a judge, they really don't know the rules. And the breath devices, the supervised visitation projects. Do you have anything to say about those?
Well, first, let me attribute the quote to Alice Walker, and it's my mantra: activism is my rent for living on this planet. And I would love for everyone to have that mentality. And activism means anything that one can do to make things better, no matter how small, no matter how large. My other mantra is when it's not a mantra, it's really my religion. I'm asked, what's your religion? And I respond, my religion is kindness. And that is the response that the Dalai Lama gives when he says, what's your religion? He says it's kindness. So I say to people, imagine a world where everyone is an activist, meaning you're doing something to make this world better. And also that our motivation is always that of kindness. And Corinne, I really want those watching this to understand that I'm not just a complainer. There are good things about our legal system. The very principles that are the foundation of our legal system and our nation are just the best in the world. And some of those principles are that all are created equal and entitled to life, liberty, and the pursuit of happiness. Everyone has a right to a speedy trial, a right to a trial by jury, a right against self-incrimination, a right to due process. So the problem, in my view, is in the implementation of these wonderful principles. The propertied white men who established these principles, many of whom owned people who look like me, did not contemplate that these principles would ever apply to women, to poor people, and to people of color. So the challenge for us is to ensure that these wonderful principles that underlie our legal system are applied equally and fairly to everyone. That is our challenge. And that is yet another reason why I wrote this book, to challenge all of us, because we actually can make this legal system one where these principles apply to everybody. We're not there yet, but it is a work in progress.
Your Honor, we are honored to have had your time and your insights. Your ability to educate us, entertain us, and energize us is wonderful. Please continue with your heartfelt goals to fix the world. You've got a whole chapter on it, but you have a lot more activities in your life that you're accomplishing there as well. You're working with so much community involvement with Palo Alto City Council, Stanford Special Counsel, and environmental concerns. So we are really honored to have had you here. And I urge everyone to go out and read this book because I'm going to have to get the audio version because I've scribbled all over my book and it has, little marks all over it, but I need to listen to the audio version as well.
Corinne, I thank you. And I did record the book. It took me 16 hours to record the book. And I do encourage folks who just like audiobooks to certainly to listen to Her Honor. And I thank you. I thank the work that you do. And I'd like to leave everybody, if I could, by reading the final passage in my book. And it goes like this. Judging has been the most fulfilling of my various careers. For nearly 20 years, I wielded power over the lives of thousands of people. And for nearly 20 years, I did what I believe to be right. While it is up to the next generation of voters, politicians, activists, lawyers, law professors, and judges to continue to clear the path to a more perfect union, I refuse to give up on our legal system, and I will never give up on our judiciary. Hopefully, neither will you.
Thank you so much, Your Honor, for presenting to our audience this evening. It is truly an amazing story, and one, again, as someone who has read your book, found absolutely fascinating the heartwarming and the really sad aspects of some of the things as a judge that you have seen in your courtroom. Barack Obama said, we need somebody who's got the heart, the sympathy to recognize what it's like to be a young teenage mom, the empathy to understand what it's like to be a poor African American or gay or disabled or old. And that's the criteria by which he selected judges. And I think that we are very fortunate that Governor Jerry Brown chose Judge Cordell to make her a part of our legal system because she embodies all of the things that former President Barack Obama was looking for in a judge. So thank you again this evening for your wonderful program, Your Honor, and we wish you well. And to our audience, again, I hope you are all taking care of each other, and we look forward to seeing you next month, where we will move on to a musical presentation backed by popular demand. One of our favorite string musicians will be presenting for us that night, and that's Chris Costanza. He's just an amazing musician, and we'll enjoy it. So I look forward to seeing you next month. Have a great evening. Like I said, stay safe.